So now I'll invite our lunchtime fireside chat panel guests to come up. So Justice DeWine and Elliot Gaiser, and I'll do brief intros of them before handing the microphone over to Elliot. Elliot currently serves as the Solicitor General of Ohio, representing the state and its agencies on appeals to the U.S. Supreme Court, Courts of Appeals, and the other federal courts. Before becoming the state SG, he worked at Jones Day as a litigator and a counselor. He also previously worked at the Gibson, Dunn, and Boyden Gray law firms, served as a law clerk to Justice Alito on the Supreme Court, as well as Judge Rao on the D.C. Circuit and Judge Jones on the Fifth Circuit. He also currently serves on the Alumni Board of Hillsdale College. So thank you for being with us, SG Gaiser. And another close friend is Justice Pat DeWine. He began his six-year term on the Ohio Supreme Court in January of 2017. He is known on the Supreme Court as an excellent writer with marked quality and thoroughness of his legal opinions and his foundations of strong belief in judicial restraint and respect for the constitutional roles of the branches of government. He served in all levels of the Ohio judiciary, serving for 4 years on the First District Court of Appeal and 4 years on the Hamilton County Common Pleas Court. He's also served as an adjunct professor at the University of Cincinnati College of Law, where he teaches appellate practice and procedure. And he also regularly takes on law students as externs, and they have wonderful opportunity. Our president, Dan, served as an extern in his chambers last summer. We have another Akron student, Haley Kendall, who's currently a 1L serving, who will serve with him this summer. So let's give a round of applause to both of our speakers.
Well, thank you so very much for that kind introduction, Judge Holt. Congratulations to the University of Akron students yet again. It's tremendous whenever Ohioans succeed, and you are emblematic of that in the Rubber City. And thank you to Justice DeWine for being here to talk to us today, and to the Federalist Society. You know, this is a little different. It's a fireside chat, but I think the better description of this panel would be a fern between us. I also thought, it's a little interesting. The last time that I saw you, you were asking me the hard questions. So I'm grateful for the opportunity to turn about is fair play, how the turntables, as Michael Scott would say. But thank you for being here, and thank you for joining us today.
Absolutely. Thanks for having me, and congratulations. As most of you, I'm sure, know that President Trump announced, I don't know if he announced, but it's been reported he's going to appoint Elliot to the head of the Office of Legal Counsel. I was trying to explain to someone what a big deal that was, and so I pulled up the list of people who've held that job, and let's see if I can find it here real quick. I lost it. But take a look at Google, the people who've held the job. Bill Rehnquist, Antonin Scalia, Walter Dellinger, Cooper. The list goes on and on. Jack Goldsmith. It's a phenomenal list of people. So congratulations. And when I found that out, I kind of felt like I should be the one asking the questions, because you'd much rather hear from Elliot probably. But that's not the format, so I'm ready.
Well,
Fire away.
So I think the best way maybe to start this conversation is to ask about the law of Ohio, and what is Ohio's law, and why is Ohio's law inherently originalist?
Thank you. I think that's a great question. And some of you know, I recently wrote an article about that, talking about how we should interpret the Ohio Constitution. And when you think about the Ohio Constitution, you start with the premise that under the Constitution, Article 1, Section 2, all power is inherent in the people. So power comes from the people of the state. And everything that's part of our Constitution is a part of our Constitution because Ohioans directly voted on that. Our original 1851 Constitution was directly submitted to the Ohio people for a vote, And every amendment since then has been directly submitted and approved by the voters. So what makes something law is the fact that voters approve that constitutional amendment or provision. And if you believe that, then the only way to give effect to that law is to apply it based on the way that the voters understood that provision when they put it into the Constitution. Anything else substitutes the democratic will of the people for a judge's will, and that is not, I don't think, appropriate. And historically, that is the way the Ohio Supreme Court has looked at the Constitution. Really, the most famous case, most important case, I think, in Ohio history is Rutherford v. McFadden. You may not know it, but you should. It's an 1807 case, established the power of judicial review in Ohio, but it also interpreted a constitutional provision. It interpreted the right to a jury trial. And the way the court did that is by looking at what the jury trial right meant when it had been put into the Constitution a few years earlier. So from the beginning, the Ohio Supreme Court has recognized that the way you apply the Constitution is to look at the original understanding. Now, I can't say the Ohio Supreme Court has always been faithful to that. You can certainly look through our jurisprudence for 200 years plus and see lots of times when the Ohio Supreme Court has departed from that. But it's never suggested that there's another way to understand the Constitution. Even when the Ohio Supreme Court hasn't been faithful to that, it's always, I think, been the premise that original understanding is how we understand the Ohio Constitution. And the last thing I'd say on that point is, if you talk to people who defend a living Constitution methodology, particularly what they say is, well, the federal Constitution is so difficult to amend that we really can't expect its meaning from hundreds of years ago to apply today, and so judges have to find changing meaning in the federal Constitution. Now, I don't buy that, but when it comes to the state Constitution is not that difficult to amend. The legislature can put something on the ballot, and it can be amended by a majority vote, or the people themselves have a process to amend the Constitution. So if the people can change the Constitution, there's no good reason that judges ought to be doing that work for them.
I think that is one of the unique aspects of living in a state like Ohio, is how easy our Constitution is to amend. And of course, that ease of amendment also produces an ease of litigation about those amendments. And so I'm curious to know, from your perspective, what types of sources, how do you discern the original public meaning of a constitutional amendment, especially one that is fairly recent? What are the sort of materials that judges should look at? And then those representing litigants before your court, what sorts of things should we be citing that would be persuasive and helpful?
Sure. I think the starting point is always the text. And in many cases, that's also the ending point. Particularly, the Ohio Constitution is easy to amend, and you can make a pretty good argument that it's perhaps too easy to amend. But the system is what it is. And one of the things that's happened in recent years is that not all, but many modern constitutional amendments tend to be written more like statutes. They're pretty precise. You don't see the kind of open textured language generally that you see in the original Bill of Rights, or even the original 1851 Constitution. And because many provisions are written like statutes, that frankly makes the interpretive job easier, and text is often the only thing that you need. But there are provisions that are indeterminative, that are undeterminative, and so then the question is, what other sources do you look at to understand that. And I've suggested a variety of materials that could be helpful depending on the context. I think that we have not done this, but if you're trying to understand what language meant at a specific time, I think the tools of corpus linguistics could be useful in doing that. Many provisions in the Ohio Constitution are carried over borrowed from another constitution. If we're looking for original public meaning, we're looking at the meaning that it had in Ohio at the time it was enacted, what a reasonable voter would have understood the provision to mean. But oftentimes, that understanding can be informed by the understanding of the prior constitution. Whether it's another state constitution or in some cases the federal constitution. So, the interpretations of that in other states or by the U.S. Supreme Court up until the time it was put into the United States, to the Ohio Constitution, can be helpful. Now, I don't think decisions after that are much help. When Ohio enacted a provision of the Ohio Constitution that parallels the U.S. Constitution, Ohio voters probably understood how it had been understood by the U.S. Supreme Court up until that time, but they certainly weren't opting in for all future years to whatever the U.S. Supreme Court might decide to go. Beyond that, there are times when you need to understand the mischief, really, that something was aimed at, the historical moment. The goal is to understand what those words would have meant to a reasonable person. But just like all conversation happens in context. And certain things were put in our Constitution at certain historical moments, so the voter would have understood the historical context, and those words need to be understood as part of that.
Yeah, I think that there's, when you're thinking about the original public meaning, sometimes there can be a temptation to look at it as a pure empirical question that courts maybe have a little bit more of a hard time looking at versus an objective question about how are words generally used in sort of a reasonable conversation.
Right. I mean, that's right. We're not looking for kind of the hidden meaning that someone may have subscribed to this, but to the meaning that an ordinary, reasonably intelligent voter would have ascribed to it at the time that they enacted it.
Well, so to put a specific point on this, one of the cases that certainly I think deals in some of these particular issues is the Cincinnati Enquirer standing in state ex rel against Bloom, which had to do with the Open Courts Amendment in Ohio. Would you want to talk about how originalism informed that decision for the majority of the court that you wrote?
Sure. So Bloom was a case where allegedly a police officer had testified at a juvenile's trial and said that he had witnessed the juvenile stand over the victim and shoot the victim. This I don't have the transcript, so this is just what's in the pleadings. And the juvenile court judge found that juvenile not delinquent and sealed the transcript. And the Cincinnati Enquirer filed a lawsuit to get a copy of the transcript. And so we have something in our Constitution called the Open Courts provision. Dates back to 1851, original Constitution. It says, quote, all courts shall be open. So their argument was premised on that provision. The challenge they faced was that in the 1990s, the Ohio Supreme Court had said, we're going to lockstep that provision with what the United States Supreme Court has said that the First Amendment means. So the right of courtroom access that's been found in the First Amendment. Now, and so our precedent is going to be whatever the United States Supreme Court says the First Amendment means, the open court provision means. Now, if you think about that, that's nuts, right? I mean, there's nothing in the U.S. Constitution that talks about open courts. Nothing, there's not a word. But we have a separate provision in the Ohio Constitution. But the Ohio Supreme Court said, well, it doesn't mean anything more than the First Amendment. And if you looked at the First Amendment case law, juvenile courts probably weren't covered, because they had, the United States Supreme Court had said only courts where historically there'd been a right to access. And so there's been a lot of at least implications in this case law that juvenile courts wouldn't do that. So the first question we had to confront was whether we're going to follow that precedent that says we just lockstep with the U.S. Supreme Court. And we decided that, notwithstanding principles of stare decisis, that we were going to abandon that precedent. And we didn't do that lightly, but what we said was, this isn't a case where the Ohio Supreme Court examined the text, history, tradition behind the provision and said it meant what the First Amendment meant. This was just a case where the Ohio Supreme Court, without any examination of text, history, or tradition, had said, we're just going to follow the U.S. Supreme Court. And ultimately, we take oaths to both the U.S. Constitution and the Ohio Constitution. And if we're not interpreting the Ohio Constitution, if we're just ceding that right to the U.S. Supreme Court, we're not following our oath. So we felt in that case, after looking at the text of the provision, the history of it, that it was appropriate to abandon that prior precedent. And then we had to go back and look at what that provision meant at the time that it was put in the Constitution. And frankly, that was a tough thing. One of the things about doing originalist research when it comes to the Ohio Constitution is there's not a lot out there. If you're doing that research for the U.S. Constitution, for any provision, you can find hundreds of law review articles. You can find basically zero for Ohio. So we had to do that ourselves. One of my law clerks who worked in that case, Nathaniel Falk, is here. He did a great job doing some of that research. But ultimately, we determined that the meaning, all courts, was in accord with its text. That didn't just apply to some courts in Ohio, that the open courts provision applied to all courts. And if all courts are open, that meant the inquirer had the right to the transcript in that case.
Well, I think that case in particular, and I commend to all of you to read that as an example of how both stare decisis in Ohio Supreme Court precedent works, as well as originalism. And I know this is a plug that you've made before, Justice, but if you are looking for a law review article topic, a note topic, if you're a young lawyer and you can get pro bono credit or writing credit billable with your law firm, write about the Ohio Constitution and some of the provisions in the Ohio Constitution. Collect some of the newspaper accounts and some of the discussions around various provisions that have not been interpreted, and that will you can have a profound impact on the debates and the litigation surrounding these particular cases. Certainly, as someone who litigates under the Ohio Constitution, that would be very useful from my perspective. Shifting gears just a little bit to the Ohio Constitution and the Ohio courts, there's been a lot of debate about the scope of injunctions, nationwide injunctions, universal or cosmic injunctions. In the federal court system, do state courts at larger in Ohio, do they have a similar problem? Do some of those arguments come to bear?
Sure. And I'm not going I'm going to be careful what I say about this because we may have some cases that come before us, so I'm not going to say anything that I haven't written, didn't write in a concurrence at least. But yeah, that is a challenge in Ohio. Typically, we will see cases where a plaintiff will file before a single common pleas court judge. And in many cases, they have 88 counties to choose from where to file their lawsuit. And then the common pleas court judge will issue an injunction that applies not just to the parties, but to enjoin the law for the entire state, for all potential applications. This issue came up in a concurrence that I wrote in a case involving the Ohio statute about protecting minors from sex change, puberty blocking, that kind of thing. And the judge in that case had two plaintiffs in front of him, but it issued an injunction initially, TRR initially, that applied not just to those two people, but enjoined the entire state law, even provision of the state law that didn't deal with their situation at all, even provision of the state law, for example, that dealt with boys playing girls sports. And so procedurally, that wasn't the right case, I felt, to deal with the issue. It was a mandamus action. There were some other procedural hurdles. But, I wrote a concurrence that says, this, in an appropriate case, this is an issue that the Ohio Supreme Court really needs to look at. To some extent, the legislature has stepped in a little bit since that case and made clear that a preliminary injunction was immediately appealable. Before, that had been a question in Ohio. Under what circumstances would a preliminary injunction be immediately appealable? The legislature passed a new law that said that, at least when you have injunctions against a state law, that can be immediately appealed. So that will at least ensure that those cases get more quick review by the appellate courts. But there's still an outstanding question about when and under what circumstances is it appropriate for a single trial court judge to issue interim relief that goes beyond the parties and extends universally.
Yeah, and it's certainly a hot topic. Lots of scholarship has been written about this at the federal level, but less about it at the state level. I think some of the principles in that scholarship might come to bear. Another area where I think federal and state scholarship has started to move, and actually I think Ohio has been a leader, is in the administrative law. Of course, people think a lot about the Administrative Procedure Act, the federal administrative state, but states also have large administrative bureaucracies that administer the laws and adopt regulations. One big topic has been deference, another is the question of delegation. Ohio was a leader. We had a case called TWISM. I don't know if you're interested in talking a little bit about that one, where the sky did not fall, and the Supreme Court of the United States, I think, in many ways, was able to look to Ohio as a beacon.
Yes, so as many of you know, a few years before the Loper-Bright decision, Ohio issued a decision, TWISM, which essentially said that there is no mandatory deference in Ohio, that judges are never required to defer to to an administrative interpretation of a statute, and that actually I thought was interesting. That it actually was kind of alluded to at oral argument in the Loper-Bright case, which I think Justice Kavanaugh asked the U.S. Solicitor, said some states have done this. The world hasn't come to an end. Why would it if we do it? And that's true. So we have done that. I really haven't seen. I mean, lower courts seem to be pretty successfully implementing that decision. We haven't seen more cases. I haven't seen anything to think that it's been a problem in Ohio. And I was actually asked, following that, the University of Michigan Journal of Law Reform asked me to write an article on state administrative law. So I kind of wrote an article talking about the aftermath of that decision and just administrative doctrines generally in Ohio and the states. And, a few things are interesting. One is, Ohio historically has a much more robust non-delegation doctrine than the federal government does. And maybe because of that, we don't see a lot of challenges on non-delegation grounds. What we do see a lot of are challenges about the scope of the administrative agency's authority. And interestingly, like before TWISM and Loper-Bright, all those cases kind of came to us everyone just argued them as deference. You should defer to the agency. You should not defer to the agency. And I think the reason those arguments were there was that the whole debate about administrative deference was just so loud and overpowering. But since we've got rid of since TWISM, we've got rid of administrative deference, mandatory deference. I think those cases have been more carefully presented, because what most of them are really about is not should you defer to the agency, but did the legislature really give the agency this power at all? And so I think that's what we see in a lot of cases. Is this a power that was actually deferred to the agency, that delegated to the agency?
Well, and one thing that I've observed since beginning my time as state solicitor is that when the courts say that General Assembly didn't provide this type of authority to any state actor, usually the General Assembly can move with some level of alacrity. I think of the Dudley case where your court said that there wasn't an authority, and as of April 9th, there will be that authority because the General Assembly in Ohio can move quickly when the court says you didn't actually do this in the law, but you could, right? I think that could also be an example.
Yeah, I think that's absolutely true. I mean, I think one of the things that creates so many pressures in the federal system is the inability sometimes of Congress to legislate, to adapt to new circumstances. And because Congress seems unable or unwilling to legislate, there's a lot of pressure. Presidents try to do that. Administrative agencies try to do that through varying statutory interpretations. I don't really think that's a problem in Ohio. I mean, our legislature is not unwilling or unable to pass laws. And so I think that makes for a much healthier system when policy changes are coming from the legislative branch rather than through the administrative branch under the guise of interpretation.
So if we could shift gears just to another area of law where there are federal-state parallels, or maybe lack of parallels, state standing. There was a recent decision, Martin's, that overruled a past decision of the Ohio Supreme Court called Sheward. I don't know if there are a lot of young lawyers in this group maybe don't know about what Sheward stood for and why Martin's is significant, but maybe you would want to mention that.
Sure. When I used to give talks about Ohio Supreme Court case law, I used to have a list of like 5 important decisions people should know about. And I always put Sheward on there as an example of kind of the worst decision the Ohio Supreme Court ever issued. Now, maybe it's not the worst, but it's pretty close. And so to back up, the context for it was that there was a back and forth between the Supreme Court and the legislature about tort reform. The legislature kept passing tort reform initiatives. Supreme Court kept striking them down. So finally, the legislature passed another comprehensive tort reform issue. You would think that would be challenged by someone in a case where filed a personal injury case or whatever, damage caps applied, they appealed, that went up to the Ohio Supreme Court, and the Supreme Court would rule on whether or not it's constitutional. That's the way things are supposed to happen in our legal system. Well, in Sheward, the plaintiff's attorneys said, nah, we're not going to do that. That's too hard. We're going to file a writ of mandamus in the Ohio Supreme Court asking the court to find this legislation unconstitutional prospectively. Really a procedure never applied. So you have someone with no injury and someone without even a case going on who comes to the Ohio Supreme Court and asks the court to strike down this law. You would think that they would get laughed out of court. But no, in a 4-3 decision called Sheward, the Supreme Court said, yeah, we recognize something called public rights standing for really rare and exceptional cases. We're going to invoke it in this case, and we're going to allow in situations where we think it's important, someone without any injury at all to come to court and challenge the constitution of the law. So that law has been that precedent has been on the books for, I think, 20 plus years. Never really 30 years, really. Never. The court kind of backed away from it. They hadn't used it. in many cases, since its inception, only 3 or 4 cases, but it was kind of out there. It was something that was routinely argued in front of the court. If you didn't have standing, you could just say, well, I have public right standing. There's a public right at stake. And so finally we had a case last year that's, I thought, squarely presented the issue. And so we were able to overrule that case and recognize that the Ohio Constitution grants the court the judicial power. Within that judicial power are some traditional standing requirements. I mean, they may not be exactly the same as the federal standing requirement, but there are some traditional injury requirements within the judicial power of what judges can do. Judges, believe it or not, judges don't just have a free rein to strike down any law they want to, regardless of whether or not there's a controversy. So we made that clear in the decision last year, which I was very happy. I always thought that was just one of the most embarrassing things the court had done, and I'm glad that we have gotten rid of that. So.
Well, the Martins opinion is certainly memorable, and you have a knack for writing memorable opinions. Would you want to talk a little bit about your opinion writing process? What goes into it? How you write?
Yeah, I mean, it's mostly just a lot of work, right? I mean, I think it's, there's a story about, I heard one of Justice Scalia's sons talk about his opinion writing process, and he said what people didn't realize was it was really hard for him. He really worked at it, and that's, to me, writing a good opinion, it's a lot of work. And when I write an opinion, I want to do a couple things. One is, I want to get the law right. That's the most important thing. But I also try to write something that's readable. I want someone to be able to pick up one of my opinions and, see at the beginning what this case is going to be about. Is this something I want to read? Most cases are stories, so I want to tell that story. And I want to write it as clearly as possible. And so, much of good opinion writing is editing, is trying to figure out what really needs to be in that opinion and what doesn't. And that's, that goes, I think there's a tendency sometimes to just look at the facts as something you dump into an opinion and then here's the law. But, the facts are just as important to me as the law part of it. And I always tell my law clerks, you need to be able to explain to me why every single sentence is in this opinion. There should be a reason that every sentence is part of this opinion. If there's not a reason for it, then we need to take it out.
Well, I certainly think that's really good advice. The one piece of advice that I've always given younger lawyers about writing is making a clear distinction in the writing process between what you want to say and how you want to say it. So start first by figuring out really what is your thesis, what are the points that support that, how do you organize that, and not at the same time as trying to do that, because the human mind is pretty easily defeated by trying to multitask too much. Then figure out how you want that to be arranged and how each sentence should work. And we are going to take some questions, I think. I have a couple more questions, but I don't want you to be surprised when I say, okay, this is the last question. So if you're thinking about questions and you want to start lining up in just a moment, I think the Justice would love to hear some questions from our audience.
Yeah. The only thing I'd add about the writing is, I think the one way you can really help yourself be a better writer is to try to be a conscious reader. When you read, try to figure out what it is you gloss over, what it is that you have to read twice. What are the things that when you're reading someone else's opinion or novel or whatever, what makes you look back? For example, I bet most of you don't read block quotes, so that. So if you don't want someone to read it, put it in a block quote. If you want them to read it, probably figure out some other way. If you come to a paragraph, if you come to a page that's one paragraph that takes up the whole page, what do? Well, you read the first sentence, you might read one in the middle, and you probably skip to the end. So, don't write those paragraphs. You want people to read them. When you come to sentences that you have to read over and over again, figure out why it is that you do that, and then try to avoid that in your own writing.
So what do you think about separate writings, concurrences, dissents? I mean, I think dissents are usually necessary if you want to explain why you're not with the majority in a given case. Can separate writings go too far? When are they appropriate? When do you think about concurrences?
Yeah, I mean, I probably tend to write more separate writings than some other people, but I don't do that lightly. I think there's needs to be a reason besides the judge's own vanity to write separately. So, often the reason is, probably the most important reason is that you don't think the majority opinion got the law right. And, I do kind of take the Justice Scalia view that if I think the law's not 100% right in an opinion, I'm not going to join it. I'll explain, why I see things a little differently. But before you do that, I always, if it's possible, try to go to the majority author and say, can we revise this, or can I propose some edits to your opinion so that we can have something we can all sign off on? Because I think having an opinion where it's joined by more justices is more effective, particularly if it's majority. So I think that's always the first step. So I don't write the concurrence lightly if I think the law is wrong. There are some other reasons that you write concurrences. I mentioned at the beginning, we're talking about the injunction case, and I thought it was important, even though we were denying the emergency relief in that case, I thought it was important to explain to people that I thought that the issue itself was very important. It's one that we need to take up. And so, there are cases where there's a reason, there's something else that you need to add that's not going to come from the majority opinion that's important. But, generally, I think, concurrences have their place, but we need to, but they should have a good reason for them.
And what about concurrences in the judgment only without separate writings? What should we make of those? When is that an appropriate?
Yeah, everyone has their own individual theory. I'll just tell you mine, and this is not saying about a colleague who thinks things differently, but I just don't do that. To me, I just feel like if a judge is not going to join the majority opinion but concur in the judgment, they have an obligation to explain why. That's just the way I see it, and I'm sure other people have their own reasons. But for me personally, if I'm not going to join an opinion, I almost always really write and explain why.
Yeah, and I, from my perspective as someone who litigates in Ohio, I really like to see, even if there is a separate writing, can offer guidance for to ensure you're on target in future cases. So this is sort of my last question before we turn it over to audiences. But there's been some personnel changes on your court, on South 65's Front Street. How's the mood? What is it like working with your new colleagues? You've been there to see some changes of the guard. How's the new court?
Yeah, I have to say I'm really excited. It's great. To be honest, I feel like for the first time not the first time, but I feel like we have a clear majority of the court who starts from kind of a textualist, originalist standpoint. That doesn't mean we're always going to agree, but I think most of us start from the same general framework, which I think is really helpful. We've got some people who've just come off the trial bench, which I think can be very helpful on the court. Everyone gets along. I feel very good about where the court is right now.
Well, do we have any questions? I see we have someone there.
Hear me? Good. Hi. I'm David Forte, Professor Emeritus at Cleveland State. Many years ago, I was at the National Federalist meeting, and Justice Scalia was speaking, and afterwards, we all got to write questions, hoping that one would be picked for him to answer. And sure enough, mine was. And my question was, how do cases get argued or discussed at judicial conference? And Justice Scalia disappointed me and many others, saying that we don't really discuss things. He said, we just say what we want to say, and then we go off and start writing. So my question to you is, by the way, thank you for your insights today. My question to you is, how are cases hashed out in judicial conference among the Supreme Court justices of Ohio?
Sure. So what happens is we have oral arguments. Then after oral arguments is done, we will all go upstairs. We have a conference room. And the first thing we do is take up the cases that have been argued. The Chief Justice will call the first case. She will say what she thinks. And then we will go around the room in order of seniority with each justice saying what they think. And that first time through, you can't interrupt anybody. So everyone gets to speak without interruption. Now that sounds pretty basic. It may sound easy to you, but it's actually really hard, or at least hard for me, because there's often times I really want to jump in, but everyone gets to talk first. I grew up, as most of you know, with 7 brothers and sisters. It would have been a great rule for our dinner table, but it was not. So we go through once uninterrupted, and then we have a conversation. Sometimes there really won't be much else to say. It'll be really clear. Everyone might agree, I'll be really clear, but generally there will be some conversation. And I've actually found those to be people pretty open-minded. I mean, there's times where people will go pull up a statute, or will pull out an exhibit, or pull out a part of the transcript and read it and argue about it. And so we'll talk about it as long as anyone wants to talk, and kind of when everyone's done, we'll vote. We'll move to the next case. And so sometimes that process might take 5 minutes. Sometimes it might take a half hour. It really just depends on the case.
I see another question over there.
Good afternoon, Justice Aaron Williott. I work up the street.
Yes.
So in a 1992 case, the Kentucky Supreme Court decided, noting some common heritage with the Kentucky and Pennsylvania Pennsylvania constitutions, determined that the Pennsylvania Supreme Court decisions on the like provisions have a uniquely persuasive authority in Kentucky. Now, shepherdization shows that they have not been particularly liberal on citing Pennsylvania cases, but I wonder, does Ohio are there any states that are uniquely persuasive in Ohio, other than Ohio?
I don't know if there's any states that just generally are uniquely persuasive. I mean, there's certainly parts of the Ohio Constitution that were borrowed from other states, and so I would think that that holdings of those Supreme Courts up until the point that provision entered the Ohio Constitution would be persuasive, or at least of some significant weight, because you can imagine that when the framers of the Ohio Constitution borrowed this provision, say from Tennessee or Kentucky, that they understood what it had meant there. So I think in that sense that those decisions can be uniquely persuasive, but I'm not sure generally that there's one state we would look to. And I would say even for those states, after we adopted the provision, I don't think that the Ohio voters were tethering the meaning of the Ohio provision to whatever the Tennessee Supreme Court would say in the future. So I'm not even sure that those decisions are particularly significant either. Of course, if you have unique provisions in the Ohio Constitution, say this open court provision, there's generally not that many decisions out there. So any state Supreme Court decision on the issue is probably going to be something that you're going to want to look at and understand the logic and see if that's persuasive to you.
Thank you.
David?
David Tryon at the Buck Institute. So do you find amicus briefs more useful to the court at the jurisdictional stage or the merit stage, or just depend on the case?
Probably more at the merit stage. I don't I don't like the idea of amicus briefs as just kind of a vote, right? I mean, I don't like the idea of an amicus brief as just kind of like, okay, the Chamber of Commerce votes this way on the case, or the Insurance Institute votes this way. To me, an amicus brief is useful if the amicus can provide something that the parties cannot. And I think, couple examples I think could be really helpful is, sometimes the parties don't have the resources or ability or the know-how to do like Ohio constitutional research, and having some kind of originalist research provided by an amicus could be very helpful. I would think. Same thing with maybe a corpus linguistics analysis in an appropriate case. The parties may not have the capability to provide that, but if the amicus could provide that, that's something that can be helpful to the court. So I'm kind of, I look at amicus briefs for the kind of analytical content that they can provide that's may be missing. The Solicitor General's office often does this in cases where they provide amicus briefs.
Thanks.
I'll wait to see if anyone else has other questions. I have one. This is just a practitioner thought, appropriate for this particular moment. What do you do when you don't have any questions from the bench in a particular case?
Well, I mean, I think that you make your argument, and if you've got time left, sit down. I think you say, if there's, you give the court some warning. If there's no questions, I'm going to see the rest of my time or something. But there's not many cases where we don't have a lot of questions. I usually ask. There's not many cases I don't ask questions, to be honest. But generally, if we do, it's a case where it's pretty clear one way or the other.
Sometimes it's a little harder than other times to know whether it's clear in your favor or the other person's favor.
Yes,
when there are no questions.
That's the challenge, isn't it?
So I think that we have a couple of minutes left. If there are other questions, will come up. But I'm happy to keep asking you some questions if you think that's appropriate. One thing that I've been curious about in the Ohio legal system as I've started to get to know it as in my current capacity. What is it that makes one kind of district court of appeals or another kind of district court of appeals? I'm curious about that kind of process because you served, of course, on the first district. As I've learned about the way that our system in Ohio works with sort of the regional district approach versus a system like Pennsylvania's where they have one court of appeals for the whole state. What are some of the advantages and disadvantages of that? And then, district court conflicts that get certified.
Sure. This is kind of my first appellate practice and procedure class at UC that I teach is kind of court design. So, we organize our appellate courts by region, which follows the federal model of organizing courts of appeal by regions. That may just seem like obvious to us, but many states don't do that way. There's no real reason that you need to have geographic courts of appeals. You could have a set number of court of appeals judges for the whole state. They could just be assigned in individual panels. There's pluses and minuses both ways. You have less potential for inter-district conflicts if you have a unified court of appeals. You don't have. You may have. There may be regional differences that people think are important to have in the court of appeals. You lose that with a unified appellate court. I'm not sure that one system is better than the other. Our system is definitely a little less efficient, but that's historically the system that we've had in Ohio.
Yeah, so other states are also doing other things with court design. Of course, Texas recently created a business court. They already had a separate court of criminal appeals from their state Supreme Court. What are your thoughts on the advantages of that versus Ohio's system with a unified state Supreme Court that handles basically every type of case?
Yeah, I'm not a big, there may be room for some kind of commercial docket, some of the things. I think some of those things can be helpful, but I'm just generally skeptical of specialized courts. I mean, I think the way the law works is that the understanding of one area of the law informs other understandings. And if you look at the historical practice with specialized courts, what's tended to happen is they have kind of tended to go their own direction and lose sight of some of the larger legal principles. So, I generally like the system of our judges doing criminal and civil cases because I think there's principles that apply across the legal system.
Well, thank you very much, Justice DeWine. I can say this, as a state solicitor, I talk to the solicitors general in other states. And from my perspective, in that sort of college of SGs, Ohio is blessed and lucky to have the court that we do and to have a justice like you with the ideas that you bring to bear. So please thank Justice DeWine. Thank you all for your time and attention today.
Great. Thank you.